The appellant in this case was charged and convicted upon murder of Jenny, despite the facts that the body of the deceased was never been discovered. The prosecution in this case wholly relied on circumstantial evidence in order to prove that the appellant had committed the crime towards Jenny. Those evidential facts are: the appellant was declared as a bankrupt a year earlier and was remanded as a bankrupt on the day the offence was committed. The deceased were insured again with certain insurance policies. Next, the appellant's mother was nominated as beneficiary under certain policies of the deceased. The deceased had made a will and nominated the appellant's mother to become her sole beneficiary. The important note under this case is the deceased was a novice diver. Perhaps she was allowed to dive alone into the sea water, which was dangerous and hazardous to her. The appellant even did not jump into the water when she failed to come up onto the surface of the water. She had failed to wear gloves, which the appellant contended at the initial stage the intention for being there was for looking corals around. There were 2 cuts around the flippers which were worn by the deceased when she was diving into the seawater. Perhaps the final one, the appellant had claimed for a formal claim under insurance company after 6 days of the deceased's disappearance happened. Circumstantial evidence is an evidence which produces an inference and leads to an end conclusion. In this case, I am very much amazed looking at those facts had been arranged by the prosecutors to be tendered as an evidence that the appellant had committed murder towards the deceased in this case. The circumstantial evidence that produced in the court will ensure the court to discharge or convict the appellant upon the offence committed. In this case, I am so much satisfied that the appellant had been convicted and sentenced to death, as the facts have been proven by the prosecutors. Section 5 of the Evidence Act 1950 stated that the evidence is relevant, then it is permissible. Perhaps in this case, circumstantial evidence is admissible. In the case of Juraimi Hussein versus Public Prosecutor, Datuk Mazlan had been murdered. There was no direct evidence. Perhaps the prosecutor tendered circumstantial evidence to the court. The deceased's body was recovered from the home stayed by 3 appellants together. The cause of the death of the deceased was due to a weapon used, and such weapon was found as an axe in the similar said premise. The same cash notes denominators used by the appellants were the same cash notes denominators withdrawn by the deceased 1 day earlier before the murder was committed upon him. Certain things of the deceased was in the possession of the appellant. It was also said that the second and third appellant was in financial difficulties. There was also observation made that the second appellant was last seen together with the deceased, and the deceased body was buried in a hole which was digged around their housing area. Thus, it can be clearly seen that the act of burying the deceased body is a pre-arranged plan upon committing murder towards Dato' Mazlan in this case. Therefore, the accused was convicted and sentenced to death. Moving on to the next case, which is Padmanabahan anak lelaki Nalianan and others versus Public Prosecutor, or is mostly known as Sosilawati case. Circumstantial evidence in this case are clearly seen, whereby Dato' Sosilawati and her 3 aides were last seen together with the 4 accused in a farm in Banting before they were reported missing. In short, when Datuk Sosilawati and her 3 aides entered into the farm belonging to Padmanabahan, an opportunity was afforded to the 3 accused to carry out the murder. The preparation of the murder can be seen from the logs and the fire which had been fired during the crime scene. Human bones are being recovered at the nearest farm and the rivers by the doctor. The accused were convicted and sentenced to death for the proven circumstantial evidence around the surroundings which were found in this case. To conclude, even without first-hand evidence, criminals might be charged under the offense of crime they have been committed with just the usefulness of circumstantial evidence if it is supportive enough, and the way of improving it might be avoiding the principle of reasonable doubt. This is because it would ensure the court by not dismissing the accused who had been the facts had been proven by the prosecutors that he had been committing the crime, and just because the reasonable principle doubt had been raised and the accused are being dismissed upon the case and are even being dismissed upon the offense they have been committed, and it is seen to be unfair to the case and even to the court.